right, Ms. Smith, you're still on deck. All right, Commissioner Elam.
Thank you, Ms. Smith. If we could go back to the discussion we were having prior, and we had mentioned the code section 150. You talk about that section in your, I'm looking at your direct testimony for the progress docket, on page 12.
Okay. All right, I have it.
Okay, down at line 18, it says the cost caps prescribed by law inherently reflect an allocation of cost among customer classes and set an overall budget under which the company must operate.
Yes, sir.
And I'm interested in the term budget and how that relates to section 150. In your opinion, does section 150 establish a budget that you cannot go over spending the $12 a year times your number of residential customers?
Yes, that does establish a budget.
Okay. Now, when we're talking about what you've got here, you have foreseen that you're anticipating going over that budget.
The way that the budget is established is an allocation, say, if you look, it's in here somewhere. You do the $12 times the number of customers, and you do the commercial, the number of customers times the 120, and then the industrial customers times 1,200. You get a certain, so let's say you have $15 million total when you get down to the bottom.
Is that an aggregate of all three classes?
Yes, that's an aggregate of all three classes. And so your residential may have, say, 20% of that aggregate. Your commercial, because commercial normally has more customers, will have 50%, and then the industrial will be 30% of that aggregate 15 million. So that sets the budget, the 15 million. So that's what we consider our budget.
Okay. Do you consider that the statute sets a hard cap on the amount that you can spend on DER programs in a given year?
Let me go a little bit further. Okay, I think this will help. So that sets our budget of $15 million. Then we spend our $15 million. Let's say we spend exactly $15 million, and it's allocated per firm peak demand. So you take that, there's a conflict between allocation processes. So the way our budget is set and the way we allowed to recover our costs from the individual customer classes is based on the number of accounts times 12, and that's how we can recover. But the allocation of cost is based on firm peak demand, which is a different allocation factor. And I have a table. It's probably easier to look at. If we can go to my table, it is.
While you're doing that, Ms. Smith, let me ask you to use that other microphone. It just seems
Is
to
that not
amplify a
working?
little bit better.
I'm sorry. Okay, it's page 13. And at the very top of the page, I have a table. And this is where we calculate our budget and or our caps. This is how much we're allowed to recover. So in this example, we have approximately 141,000 residential customers, and we're allowed to charge them $12 for each account, for each account. And so we got 1.7 million. The commercial is 30,000 customers at 120, 3.7 million, and then the industrial is 399 customers at 1,200 for 478,000. So this lets us know that per the cap, we can spend $5,800,000. So, but as you can see, we do a percentage to total. Of that $5,008,000, we can recover 27%, or 1.7 million from residential, 63% from commercial, and 8% from industrial. But then we go out and we spend our $5.8 million. But we take that 5.8 and we spread it on firm peak demand percentage. And of the firm peak demand of the prior year, residential gets 60% of the 5.8 million, even though they're only 29% of the budget. Commercial gets 27%, and they're normally under the percentage of their cap. So they're like 63% of the cap, but we only allocate them 27% of the cost.
Let me go back.
Okay,
Section 150.
yes.
Is it your testimony that the commission can approve a DER plan that may have some classes going over budget, and while maybe commercial doesn't? Or is it just a sum of the three classes, and that's the budget?
Yeah, it's the sum of the three classes, and that's the budget.
And so you're saying the commission could approve that in that instance?
Yes, and that's what we're saying. So we have the 5.8, and let's say we under recover from residential and from industrial, because we can only recover 1.6 million from residential. So we'll under recover that year. So we'll take the difference the next year, allocate it among all classes, and then we'll collect it in the next year.
So it's also your testimony that that allocation among all classes that you're doing on the carry forward
Yes,
is consistent with the act?
yes, no customer class will ever pay more than their cap.
Okay, I get that.
Yeah.
I'm just talking about the costs of the classes. Your testimony that the statute does not, in essence, require each customer class to stand on its own.
Correct.
If the companies carry forward any costs in excess of the per account annual cost caps to the subsequent year, what happens to that access? We may have discussed this, but
Okay.
let's talk about it again. Does it remain within the DER capped line even though it's allocated to all three classes by that environmental factor?
It'll be allocated for the firm peak demand again. So we'll take the $1 million and we'll allocate it, say we're $1 million under recovered on residential.
Right.
We would take that $1 million with carrying cost and allocate it on firm peak demand over all three classes in a subsequent year.
And once you allocate it, it's still subject to the DER cap?
Yes, it
because
is.
it's part
Yes,
of
sir.
that DER charge.
Yes, it is.
Is a DER program which is expected to carry forward costs like that in excess of the per account annual cost to the subsequent year, that's consistent with the statute?
Yes, and it's, if we didn't have the allocation conflict of allocating the cap on the number of accounts times a certain dollar amount, a cap amount, there's just a conflict there with the amount of them taking the actual cost and allocating it a different way. So anytime you have an allocation, two different allocations trying to match up, it's going to cause a problem. And this was the simplest way we could see to remedy that conflict within the legislation.
Yeah, you talked about that in your testimony as being a disconnect.
It is it's a disconnect.
And the disconnect is that it's surely going to cost more than you can recover under the caps?
Well, it's not going to cost more. Like, we will just spend the $5.8 million in this example. But so even if we spend the $5.8 million, if we spend at the cap, the next year we are not going to be able to recover all of that because we can only charge. So let's say it's $10 million. we're allowed to spend 10 million. The residential customers of that 10 million contributed, their portion of the cap is 2.9 million. And that's all we can recover from these the residential customers is 2.9 million of the 10 million we've spent. And the 10 million is our cap. So, but when we go and take that amount we spent, which was under the cap, under the total cap, we have to allocate that cost by firm peak demand. And so residential only makes up 29% of the total dollar cap, but we have to allocate 60% of the cost to them due to allocation on the firm peak demand.
Why do you have to allocate it that way?
Because that's the way we allocate environmental costs, and that's the way the
Why do you have to allocate it per environmental cost? Does the statute say that?
Yes, it does.
It does?
Mhm,
Okay.
yes.
Let's see here. Does the statute envision these carryovers? Does it talk about it?
Yes, I think it does.
Where?
There is a section that says, oh, I'm sorry, I don't know the code off the top of my head.
It's not in the 150 though, right?
No, I think it is, actually.
Really?
I'm sorry.
Okay.
But it says you're allowed to collect any unrecovered cost in a future period.
Okay. What happens if all customer classes reach the cap, the budgeted amount, before you reach the 2% peak?
In any
Limit.
given year,
Totally, for the whole 5-year period or beyond?
the way they've put programs in place, Witness Marina's group and Witness Felt, to make sure we can meet those without going over our caps.
Okay. And, but if it does?
If it does, the legislation says we can recover our costs until we recover all of our costs. We can keep charging a DER charge.
Okay.
And I will find that for you. I just don't know what the section number is right now.
Okay. Thank you.
You're welcome.
We'd like to know where in the legislation where in the act that is. So
Okay.
Mr. Ellaby will put you to work. You
And
already know?
And I don't have the
Yes.
act with me, I'm sorry.
Okay.
Is this, the 5839 140F says the authorization to propose or approve new components of DER programs shall sunset and expire on January 1, 2021, provided, however, that the cost recovery provisions of this chapter shall remain in force until the costs associated with all approved DER program components have been recovered. That's what we believe allows to carry over, as Ms. Smith has been describing, the carryover provisions allowing, when you hit the caps, you can't recover anymore in that year, and you carry it over, and the legislation contemplated that would extend beyond the period of the programs themselves.
Okay, tell us the code section again, please.
It's section 58-39-140, subsection F.
Okay.
And if I may clarify, yeah, we talked about that, but we also talked about whether there's a portion that just contemplates the year-to-year carryover from the start, and you said there was something there.
We have certain years further out where after you get, in the beginning, we're not spending all the way up to the cap. So, for example, the cap's approximately $6 million for Duke Energy Progress. I'm sorry.
I've got the section that he's,
Okay.
Mr. Castle, my co-counsel, directed me. On that one is same section, but subsection B. And about the middle of the paragraph, the commission shall direct the electric utility to place in effect an amount designed to recover during the succeeding 12 months, the incremental or avoided cost determined by the commission to be appropriate for that period, adjusted for the over-recovery or under recovery from the preceding 12-month period. It's a very similar process to the fuel proceeding that we're all accustomed to. Excuse the interruption, Ms.
Oh, no, that's okay. I'm glad you had that. So, I usually carry that legislation around with me, but I left it in the car.
All right, Commissioner Whitfield.
Thank you, Madam Chairman. I'd just like to follow up based on what Mr. Ellaby just read and the questions that Commissioner Elam just asked you. Could you, particularly as it pertains to the last line that Mr. Ellaby just read, the example you used in your chart that you went over at the top of page 13, you had 5.8 million, and you had it broken down into the 29% residential, 63 commercial, 8% industrial, and then you described the way you would have to collect any overage over that is on the firm peak demand percentages of 60%, 27%, and 13% residential, commercial, industrial respectively. My question, I guess, is if you've collected the 5.8 million and say you use the example, of course this is not in your chart now, but you use the example of 10 million, you would continue to go forward in future years the remaining uncollected balance, and it would come back before us as an under recovered amount of 4.2 million, and then we would, as based on what Mr. Ellaby just read, we would set the new rate, the new tariff, just like we do in a fuel proceeding for fuel and environmental, but it still would have to correspond to those firm peak demand percentages until you collected it on out. So it could be spread out over a couple of years. Am I correct?
Yes, because it could be, yes. But after a while, after we hit a certain amount of spend, we expect our spend to start going down. Because, for example, with the 10-year subscription fees, we'll actually have a DER incremental charge after 2020 because that's the programs are longer.
Correct.
So say that we hit the cap in 2017 and we can't recover. We're spending up to the cap and we cannot recover all of our recovery from the residential customers because of this allocation conflict. Then, but in 2018, you know, we're getting closer to getting our goals met, and say we only have to spend $2 million that year. Then we just add the under recovery to the $2 million and we spread it. So eventually it goes away. You know, we're spending so little that the under recovery we add to the current spend will be under all three classes individual caps. Does that make sense?
Yeah, yes, and based on that and what Mr. Ellaby read, we would have to come back in and set a new factor to help you get to that, to get back to zero.
Yes, sir.
Okay, thank you.
Yes.
That's all I have, Madam Chairman.
Commissioner Hamilton.
Thank you, Madam Chair. Happy to, Ms. Smith, I know you're happy to be here.
All right. It's always nice to be here.
Well, that's good. Let's move over to the settlement agreement if we could for a minute.
Okay.
And we talk about some accounting there. On paragraph, I believe, B26 of the settlement agreement, you discuss moving incremental costs subject to the cost cap and from avoided cost. You're going to take your avoided cost and you're going to mix them until you get all you can get out of them, I guess is the simplest way to say it.
Yeah. Basically, our avoided cost is a proxy for the company's traditional generation when we do like our avoided cost hearing.
Yeah.
So with the renewables, that portion above our traditional utility generation is what we call the incremental.
Right.
So that's how we'll determine the avoided cost to go through fuel as a per kWh or per kW like environmental, and the amount that will go through the incremental will be subject to the cap. The avoided cost will not be subject to the cap.
But the the cost will be transferred over, though, won't they? Some of the costs, as I understood it.
Some of the costs will be incremental.
Yeah.
So let's say we're purchasing, with these RFPs that go out, avoided costs, for example, might be $60 a megawatt hour right now. I don't know what the avoided cost is right now on the tariff sheets for purchase power for CSP or PP, but let's say it's $60. And all the RFPs come in, and the lowest bid is $70 a megawatt hour. So they just say it's $70 a megawatt hour, so we take our avoided costs that are approved in South Carolina of $60 a megawatt hour, and we recover that through the fuel factor, like purchase power, and then we take the $10, the difference between the amount above the avoided cost, and that would be the incremental portion.
Okay. I think, in trying to understand this, is the treatment of these costs as you've discussed, are these in provision with the Act 236?
Yes, they are. It says that you apply the avoided costs that are approved by the commission at the current time, and anything above the avoided cost is your incremental cost.
Okay.
Yeah.
Thank you, ma'am.
You're welcome.
Commissioner Howard.
Good afternoon, Ms. Smith.
Good afternoon. How are you today?
Stressful day, isn't it? In the settlement agreement, you discussed the solar rebates for non-residential customers. When the total incremental program cost increased from, I think it's 75 cents to $1, what did that do to the solar rebates, the total of it?
That would actually be a question for witness Marino.
For witness who?
Witness Marino.
Oh.
I'm sorry. I'm
Is
sure
he
they went
able to
up.
answer it? Is he able? Ms. Dillon? Ms. Dell? Yeah, let's bring him back. I'd be curious to know what that was.
Okay.
Well, let's finish with Ms. Smith, and then we'll get back to that. Is that? Yeah.
That's all.
That's all.
Commissioner Randall.
Thank you. Just one quick question here to just go back to something we talked about with Mr. Marino and with Ms. Felt, about the subscription fee. In the settlement agreement, when we were reducing it by 50%, I guess the original was based on cost. Who pays the other 50%? Is it going to increase the cost for the other customers, or
Yes, sir.
So it will?
Yes.
Okay.
The cost will still be there, but just, it'll shift who pays that
It's
cost.
just going to shift. Okay, thank you.
You're welcome.
All right, any other questions for Ms. Smith? Redirect, Mr. Ellerby. Speak into a microphone, please, Mr. Ellerby.
Sorry about that. Thank you. Commissioner Elam asked you some questions about how this charge might appear on the bill. Are you involved in your job with the design of and the information that goes on customer bills?
No, I'm not.
Okay. Do you have an understanding that the consideration of exactly how the charge will be reflected on the bill is something that's still under consideration by the company?
Yes.
Okay. Thank you. I have no further questions.
Okay. All right, well then, Ms. Smith, I think you may be excused. And Mr. Ellerby, if you want to recall Mr. Marino for Commissioner Howard's question. Mr. Marino, Ms. Wee will re-swear you just for the record.
I do.
Ms. Marine, I saw you looking frantically through a notebook, so I assume you have the answer.
I heard that the question was related to a change in a cost estimate related to a dirt component change, so I just wanted to double check that we have the
Incremental
figure.
cost increase because of
Yes, if I understand the question correctly, is how much do the total costs change by increasing the rebate amount? Is that correct?
Yeah.
Cost increased by about $8 million.
$8 million
Yes, sir.
because of that increase in 75 cents per dollar.
Yes, over the length of the program, so it's beyond 5 years.
Okay, all right. Thank you very much.
Thank you.
Thank you, Mr. Marino.
Thank you.
Mr. Ellerby, Mr. Castle?
That concludes that one.
Okay, excellent, thank you. Ms. Roberts, would you like to go next?
Madam Chair, while we're taking this transitional step here, we would, that concludes our direct case, and we'd like to ask that the commission mark the companies, both Duke Energy Progress's and Duke Energy Carolina's applications as hearing exhibits as well.
Okay. We will make them hearing exhibits number 5, right, in both dockets. So we'll go over all the exhibits at the end, but the application will be hearing exhibit number 5. All right, Ms. Roberts, thank you.
Good afternoon, Commissioners. Again, my name is Stephanie Roberts. I'm here from the law firm of Spillman, Thomas & Battle, and I represent Walmart Stores East LP and Sam's Inc. East. That is collectively referred to as Walmart, and I'm here on behalf of Walmart in both dockets, docket 2015-53E for Duke Energy Progress, as well as docket 2015-55E for Duke Energy Carolinas for the applications to establish a distributed energy resource program. In these dockets, Walmart filed a petition to intervene on March 5th, 2015, which was granted March 25th, 2015. And on April 28th, 2015, Walmart submitted 7 pages of pre-filed direct testimony from Kenneth E. Baker, its Senior Manager of Sustainable Regulation. As explained by Mr. Baker in his pre-filed direct testimony, Walmart's chief concern in this case has been to ensure that the DER plans of both Duke Energy Carolinas and Duke Energy Progress acknowledge and encourage the installation of on-site renewable solar energy, whether as owned by a customer or pursuant to a customer's lease of such facilities from a third-party provider. Walmart participated in the settlement conference and in discussions among the parties to these cases, and Walmart very much appreciates the efforts made by ORS to include and address the settlement discussions, the issues raised by Mr. Baker in his pre-filed direct testimony as it relates to third-party leasing, as well as issues raised by the other intervening parties, and they worked very hard to get the settlement done, and we really appreciate it. Walmart supports the settlement agreement as submitted to the Commission, which was Exhibit 1 to each docket in these proceedings, because the settlement agreement is both consistent with the Act and clarifies the terms and conditions of Duke Energy Progress and Duke Energy Carolinas DER programs, including their respective solar rebate programs as agreed upon by the settling parties. Walmart further appreciates the Commission's approval of its request to excuse the live testimony today of its witness, Kenneth Baker, and that, of course, prevented his traveling here from Arkansas. In accordance with Hearing Officer Directive dated May 13th, 2015, Walmart submitted on May 18th, 2015, Mr. Baker's verifications of each docket that his answers to the questions posed in his pre-filed direct testimony would have been the same if given orally from the stand. And I have copies of each of the verifications should the Commission wish to attach them as exhibits to this hearing. That's all. Thank you for your time and attention.
All right, Mr. Baker's testimony then will be read into the record as if given orally from the stand, and his verification will just simply be attached to the testimony in both dockets. All right, Mr. Cully, Mr. McCullough. Mr. McCullough still isn't gonna do anything?
He told me he found his calling, so. I'm Thad Cully, the law firm Keys, Fox, and Weedman, on behalf of the Alliance for Solar Choice, and we'd like to call Justin R. Barnes, our one and only witness.
Come forward, Mr. Barnes, and if you can just sit right there at that table, and if you can use that, yes, please use that microphone.
I do.
Good afternoon, Mr. Barnes. Could you please state your full name and business address?
Justin Robert Barnes. My business address is 401 Harrison Oaks Boulevard, Suite 100, Cary, North Carolina.
And by whom are you employed and in what capacity?
I am a policy research manager at EQ Research, LLC.
And did you cause to be filed in this proceeding? And by this proceeding, I refer to docket 2015-53-E, the Duke Energy Progress. Did you cause to be filed in this proceeding direct testimony consisting of 25 pages and one exhibit consisting of your resume?
I did.
And if I were to ask you the same questions today, would your answers be the same?
They would.
And Madam Chair, I would ask that the pre-filed direct testimony of Justin R. Barnes on behalf of the Alliance for Solar Choice be received into the record as if given orally from the witness stand.
Okay, Mr. Barnes' testimony will be read into the record as if given orally.
Thank you. And additionally, I move this time for the exhibit pre-marked as Exhibit JRB-1 to be marked for identification and entered into the record.
Okay, Mr. Barnes' exhibit will be hearing exhibit number 6 in both dockets.
Thank you. And Mr. Barnes, have you prepared a summary of your testimony for the Duke Energy Progress DER program application?
I have.
Okay, please proceed.
Madam Chairman, Commissioners, good afternoon. My testimony in this proceeding discusses how Duke Energy Progress's Distributed Energy Resource Program, or DER program, meets the requirements of 2014 Act 236 and the settlement agreement entered into in docket number 2014-246-E, the predecessor to the current DER proceedings. Based on this discussion, I suggest several modifications to the company's DER proposal to better align it with Act 236 and the settlement agreement, and to improve the effectiveness of programs intended to support customer-sited solar development. Specifically, my testimony addresses 3 primary elements of the company's DER program. 1, whether it is appropriate to count shared solar subscriptions towards the Act 236 target for customer generators sized at no more than 20 kilowatts. 2, the company's proposed solar rebate incentive design. And 3, assignability of solar rebates to facility owners such as lessors of solar systems. With respect to the company's shared solar proposal, I outline why it is not appropriate at present to count shared solar participants towards the target for customer-sited systems of 20 kilowatts or less. This so-called small system requirement is established by Act 236 at 0.25% of the company's 5-year average peak demand by 2020. The settlement agreement in docket number 2014-246-6-E accordingly establishes the 25% or the 0.25% target as a minimum requirement for the provision of incentives to customer generators with on-site generation of 20 kilowatts or less. Utilizing shared solar participation to meet this benchmark could detract from the availability of DER incentives and opportunities for customers that choose to install on-site solar generation systems. Therefore, I recommend that such a measure only be considered if the net metering and solar rebate programs fail to produce sufficient customer generator capacity of 20 kilowatts or less by the end of 2020. With respect to proposed design of the solar rebate program, I recommend that the proposal put forth by the company be modified to establish an overall declining block design where incentives decline by predetermined amounts as program enrollment benchmarks are met, to also remove annual program capacity limits, and to clarify that solar rebate incentives may be assigned to solar project owners, including lessors of such systems.
These changes would support a program that is predictable, transparent, and easily understandable to solar companies and prospective participants, characteristics that are critical in determining whether the program is successful in meeting the DER program targets. The settlement agreement in this proceeding provides that shared solar participation will not initially be counted towards the small systems requirement. It also outlines a solar rebate program design that is very similar to the design I propose in my testimony and is consistent with the principles of program simplicity, certainty, and transparency. The Alliance for Solar Choice, or TASC, supports the settlement, as does my testimony. This concludes a summary of my testimony and how it relates to the terms of the settlement agreement. Thank you.
Okay, thank you, Mr. Barnes. And now switching gears to the DER program application for Duke Energy Carolinas, which is docket number 2015-55-E. Did you cause to be filed in this proceeding direct testimony consisting of 25 pages and 1 exhibit?
I did.
And if I were to ask you the same questions today, would your answers be the same?
They would.
And Madam Chair, at this time, I would ask the pre-filed direct testimony of Justin R. Barnes be received into the record as if given orally from the witness stand.
Okay, Mr. Barnes' testimony will be read into the record as if given orally from the stand. His exhibit will be hearing exhibit number 6 in this docket 55E.
Thank you, Madam Chair. And Mr. Barnes, would you like to adopt this summary you just gave of your direct testimony for the Duke Energy Progress application for the Duke Energy Carolinas application?
Yes, I would.
Okay, Madam Chair and Commission, this witness is available for questions.
Okay, thank you. Commissioners' questions. Commissioner Hamilton.
Hey, Mr. Barnes, happy to have you with us, sir. Could you tell me the difference in cost in a unit as a shared unit versus a rooftop unit?
Well, probably at a broad level. You know, I know if you were to look at, well, I suppose I don't know what specific costs are in South Carolina for residential systems, and obviously they're going to vary a little bit, you know, just based on the site itself. I participated and helped design a solarized program in Raleigh, North Carolina recently, and the bids that we got were on the order of $3.70 per watt, $3.75 per watt, somewhere between, say, $3.50 and $3.75 per watt. For a say larger ground mount system, just having looked at some recent statistics from a publication called it's published by Green Tech Media. It's kind of like their quarterly solar market reports. You know, you might see ground mount systems of, say, comparable to a megawatt in size down around, say, the $2 per watt range. That's I suppose, inexact recollection on my part, but I think the difference is, you know, can be fairly substantial. And, you know, maybe in South Carolina, the right number for residential is 340 or 350, but there's obviously going to be a fairly sizable difference.
Okay. Thank you, sir, very much.
All right, I'm sorry, Mr. Gould, I didn't mean to slight you. Did you have any questions for Mr. Barnes? Okay, thank you. Commissioner Fleming.
Thank you. Good afternoon. In your testimony, you talked about distinct market characteristics and participant characteristics for for residential solar. Could you elaborate on that, what those distinct differences are?
I believe in the context I was referring to, it was to kind of differentiate who might be a prospective participant in the shared solar program versus who might be someone more inclined to install a system on the rooftop. Is that the section you're referring to?
Yes.
Okay. Well, you know, I think as I believe one of the commissioners already asked, you know, these are kind of two very different products when you think about the level of commitment that you're making when you say install or lease a system that's going to be on your rooftop, you know, effectively for the life of the system or until you sell the home, you know, 10, 15, 25 years even, versus, you know, paying for the output or subscribing to the output of a facility based on a relatively small upfront fee that you are likely to recoup over the course of 2 years, or at least according to the projections of the company. And I think so there's a kind of a very dramatically different risk-reward relationship there, where, you know, in the long run, you could, you know, very well be much better off by purchasing or leasing a system in terms of how much energy you're going to save, what your cost savings are going to be. You're going to have ownership over something. Once you've kind of met that payback, that's a value, certainly. It's also potentially, if you're purchasing it, a very large upfront cost. So if you're, potentially on the fence about something like that, or you are a person who doesn't have the right site, you're a renter, you don't just happen to have that kind of income to purchase a system, or you don't have a credit score that's necessary to lease a system, or you've got trees that you don't want to trim, or you've got a site that doesn't face the right way, or you've got an HOA, and a neighborhood homeowners association that is potentially problematic. I mean, those are all kind of things that might steer you in the direction of participating in shared solar. And what you get for it is a fairly, I suppose, low risk type purchase. It's small at the outset. And ultimately in the long run, though, your potential savings and maybe potential benefits are a lot more limited. So it's kind of hard to say define a specific customer type that would do one or the other. But I think what you're really talking about is just two kind of very different products, each of which might appeal to different people, even at different times in their lives.
So it's the longer term investment people that would be geared more toward the solar panels.
Yeah, very much. I mean, certainly it's a commitment. If you're not comfortable with that commitment, well, you probably shouldn't install solar panels on your house.
Okay, all right, thank you.
Commissioner Elam.
Good afternoon. I don't know if you were in the hearing room earlier when I was discussing insurance issues with Ms. Felt. And I'm interested if you are aware of any instances where there have been issues. I think certainly between if you are leasing a solar panel on your roof and what home insurance companies, the reaction is as far as who covers the roof and whether or not that somehow putting a solar panel on your roof is problematic for your homeowner's insurance as far as, I don't know, just simply if you get the roof damaged by hail.
Okay, well, so I think there are probably a couple different elements to that. I mean, one, you're talking about two kind of different ownership arrangements, one being a lease versus one, where you actually own the system. Mm-hmm. So I guess starting off with what I think is maybe, for homeowners insurance, probably the more significant is one where the homeowner is actually owning the system. And there's a couple considerations that you would think about. One, does my homeowner's insurance actually cover this? That's a question that got raised. It's been raised probably for 15 years. And 15 years ago or 10 years ago, it used to be when insurance companies just were not very familiar with solar and it was very, very rare. You might get an answer if you were to ask your insurance company, we're not sure or I don't know. These days, and while I've heard of a few isolated instances where an insurance company has said, no, we don't think that's something that's covered under your insurance. These days, there are ample companies that will absolutely say, yes, that's covered under your homeowner's insurance. The other question you might have is whether or not the coverage that you have is sufficient to cover kind of that added, we call the replacement cost of the system. I think typically, I'm trying to remember what my homeowner's insurance limit is, but I think it's on the order of, it's $300,000 or something like that. And most often, that's something that the existing level of insurance is probably going to be enough because, I mean, just depending on what your home is already valued at and what level of insurance you have, it's probably not a huge addition to that amount. A related issue would be, do my premiums actually increase because there's a higher replacement cost on my home than there used to be because I've put something worth, $20,000 or whatever it happens to be on my roof. That I'm not sure of. I think it's plausible. I think that it could, but the reason I'm not sure is just because I don't know how often your insurance company is, say, reappraising your property and coming up with a new replacement cost, and whether or not they're, say, going through permitting databases to find out if you've made that kind of addition or what kind of intelligence they have. So whether or not your premiums would increase, to me, that's kind of a question mark. But certainly, it's probably reasonable for a homeowner to contact their insurance company and verify that, in fact, it will be covered. It should be, but it's never a bad idea to know for sure.
I've known homeowners insurance companies to get to the point where when they inspect your home, they tell you you've got to paint it before, or they'll cancel your policy. Now, has the insurance industry done anything along the lines of try to enforce its own standards for the installation of solar panels?
Not to my knowledge. I guess my assumption has always been that they, trust both the local authority having jurisdiction on the permitting side of things to make sure it's, installed in compliance with the National Electric Code, and then you've got interconnection standards that are set by utilities. I've never heard of specific standards being established by insurance companies for like rooftop residential systems.
But definitely a good idea for a customer that's doing this is to contact their insurance agent first.
Yeah, I mean, that's kind of always a good idea. And same for, say, like a homeowners association. It may not be a problem, but you're better off kind of knowing upfront than, asking for permission later after you've already spent a significant amount of money. It's just good behavior, good manners.
Thank you.
Right. Oh, Commissioner Howard.
Good afternoon. I was wondering if your organization has done any demographic studies on the typical purchaser of solar panels, rooftop.
We haven't done any of those studies, but there have been a number of them that have kind of, looked at, say, large incentive programs like the California Solar Initiative and, pared that down to, where people live, relative income levels. It's something, say, that was reported as part of like the Louisiana Solar Tax Credit Program as well. So that information exists. We haven't done any studies on it though.
Have you ever heard of a Bill of Rights for third-party vendors?
As in, something that would be kind of like a standard customer disclosure.
Yeah, customer standards and what to expect. Do you know of anyone that has that?
I believe the National Trade Association, the Solar Energy Industry Association, is coming up with right now kind of standardized codes of conduct, that sort of thing. And there have been a number of instances where states have seen fit to establish specific requirements by law for either those kind of sellers of solar systems or lessors of solar systems. So that's something that probably only appeared relatively recently, but it's certainly in the news a fair amount these days.
Thank you very much.
Commissioner Randall.
Thank you, Madam Chair. Welcome. Glad to have you here this afternoon. Got a couple of questions and sort of follow-ups on some of the other commissioners' questions. Commissioner Hamilton earlier had asked about maintenance of solar panels, that kind of thing, and I've always been interested in this because, when you're talking the difference in rooftop, and you answered a little bit of the question a while ago when you said if you got a big tree you don't want to trim, that kind of thing, where you've got the difference in which is better, rooftop or shared solar that's out in the open a little bit more. Do you find in any of your work where, say, you got a house that's got a lot of oak trees, pecan trees, pine trees around it that give off a lot of junk and end up on your panel? Does that degrade the panels at all, or does that form another industry or job creator to clean those things? Because I know I just look at my car windshield and see that, and I've always wondered how, if that's a factor anywhere where it makes more sense to have panels that are unencumbered by a lot of trees that give off a lot of sap.
Well,
He's asking for a friend.
I've got this friend who has a house like that.
I've never heard of leaves being an issue just because leaves kind of tend to just blow off.
Right.
Northeast snow an issue. I would imagine, given the level of accumulation of pollen on our cars is something that sits still. I would imagine I'm not an installer or a maintainer of solar panels, so I would imagine it's potentially an issue. And just because I know in, say, the desert Southwest, dust is an issue. They need to clean the panels to get the dust off, and a material effect on how much energy that system is going to produce. On a personal level, I would love to install solar on my house, but I have a lot of trees, and I'm not willing to cut them down. So I'm an example maybe of somebody who might be more interested in shared solar just because what I've got doesn't work very well.
Thank you, thank you.
Commissioner Whitfield.
Thank you, Madam Chairman. Just one quick question for you, just to clarify what you said, I guess, here on the stand and in your testimony. If I understand it right, you were saying that the shared solar should only be counted toward the 25% requirement, and that if there's not enough, if the programs fail to produce enough customer-generated to meet that 25%, your contention was to count it, but not till the end of 2020. Is that right? I think you said wait till the end of the program till you see how many participants you have in the shared solar. Is that correct?
Or, well, I guess to kind of reprise the question, my position was that don't count it until it becomes clear that these systems that are like physically under 20 kilowatts, separate systems.
Right.
Until it becomes clear that the development of those is not sufficient to meet the target, in which case consider whether or not shared solar participation should count towards the target, I guess to the extent that these shares are less than 20 kilowatts.
In other words, you think there'll be more interest, obviously, in the shared solar and less in the smaller systems, is what you're anticipating. Is that right, or no?
No, not necessarily. My position on that was just that having shared solar count towards that target could, among other things, create kind of accounting issues with when you've got people coming in and out of the program in a way that they wouldn't necessarily do once they've installed, say a small system on their rooftop, as well as it being maybe questionably consistent with the statute, and I think probably not very consistent with the terms of the settlement agreement, was that just allowing shared solar participation within that 0.25% target, which is relatively small, would potentially detract from the availability of incentives to the extent that utilities decided to stop offering, say, a solar rebate once they had 9 megawatts of 20 kilowatt systems or less and 3 megawatts of less than 20 kilowatt shared solar participation. Our position was that no, that to the extent that that target for the less than 20 kilowatt system or 20 kilowatt or less systems is 12 megawatts, it should be 20 kilowatts or less systems, not shared solar.
So you got more of a wait and see approach.
Exactly. We don't know exactly what the market is how quickly it's going to develop, and it could be that 3 years from now. We do know exactly how it's going to develop, and it could be very short or it could be very, very long. So it may be a question to put off to another day, I suppose.
Thank you, Mr. Barnes. That's all I have, Madam Chairman.
All right, thank you. Mr. Cully, you have any redirect for Mr. Barnes before I excuse him?
No redirect.
Okay. Thank you, Mr. Barnes. All right, Mr. Holman.
Thank you.
Thank you, Madam Chair. The South Carolina Coastal Conservation League and the Southern Alliance for Clean Energy call Hamilton Davis and John D. Wilson to the stand.
You'll raise your right hands, please. Do you solemnly affirm the testimony
We'll begin with Mr. Davis. Please state your name and business address for the record.
Hamilton Davis, 328 East Bay Street, Charleston, South Carolina, 29401.
And can the commission hear
Mr.
okay?
Davis, yeah, if you can just pull that mic really close and just speak loudly, please.
Okay, is this better? Still kind of solid.
How
How about this?
That's
There we go.
good.
I just need
Don't
to turn
do
it on.
anything different yet.
Mr. Davis, did you cause to be pre-filed in each of these dockets direct testimony consisting of 21 pages along with one exhibit?
I did.
Do you have any changes or corrections to your pre-filed testimony?
Yes, there's one correction to my testimony filed in the Duke Energy Progress docket at page 19, line 22. The excuse me, the megawatt amount on that line should read 1.5 megawatts rather than 8 megawatts.
Other than that correction, if the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
They would.
Was the exhibit to your testimony in each docket prepared by you or under your direction?
They were.
Madam Chair, I would move to have Mr. Davis's pre-filed direct testimony as corrected entered into the records as given orally from the stand.
All right, Mr. Davis's testimony will be entered into record as if given orally from the stand.
And I would also move to have the exhibit attached to his pre-filed direct testimony identified as pre-marked Davis Exhibit 1 entered into the records.
All right, his exhibit will be entered into the record as hearing exhibit number 7.
Very good. Mr. Davis, did you prepare a summary of your testimony today?
I did.
Would you please give your summary to the commission?
I will, Madam Chairwoman and members of the commission. Since my testimony was filed with the commission in both dockets on April 28th, 2015, the South Carolina Coastal Conservation League and Southern Alliance for Clean Energy have signed settlement agreements with Duke Energy Progress, Duke Energy Carolinas, the Office of Regulatory Staff, and other parties to these two proceedings. The settlement agreements were filed with the commission on May 12th, 2015. CCL and SACE support the settlement agreements as reasonable and fair compromises that translate the promise of Act 236 into reality for Duke's South Carolina customers. My pre-filed testimony in both dockets commends Duke Energy Progress and Duke Energy Carolinas for filing applications to establish distributed energy resource programs and offers recommendations for improving the company's programs as originally proposed. First, I recommended that the companies not count shared solar subscriptions towards meeting Act 236 target for rooftop systems no greater than 20 kilowatts in nameplate capacity. Second, I recommended that the companies consider ways to make their programs more accessible to more potential participants, regardless of income level. Third, I recommended that the companies change their proposed program modification procedures to add transparency and predictability. Fourth, I recommended that the companies consider a step-down approach to altering incentive levels in the future. Finally, I recommended that the companies clarify that the renewable energy credits generated by its program be maintained for the benefit of South Carolinians. As stated earlier, CCL and SACE have signed the settlement agreements in these two dockets. The agreements address many of the above recommendations, and we believe that the settlement should lead to a successful implementation of Act 236 for Duke's customers. Solar power is an abundant, zero-emission, and cost-effective energy resource in South Carolina. Rapidly increasing its deployment will produce jobs in our state and solidify our competitive edge as a clean energy leader. We commend the companies, other stakeholders, and ORS for their hard work reaching this compromise. Thank you.
Thank you. Mr. Wilson, could you please state your name and business address for the record?
I'm John D. Wilson, and I'm with the Southern Alliance for Clean Energy at 1810 16th Street Northwest in Washington, D.C. 20009.
Thank you. Did you cause to be pre-filed in these two dockets direct testimony consisting of 12 pages along with 2 exhibits?
I did?
Do you have any changes or corrections to your pre-filed testimony?
No.
If the questions put to you in your testimony were asked at the hearing today, would your answers be the same?
Yes.
Were the exhibits to your testimony in each docket prepared by you or under your direction?
Yes.
Madam Chair, I would move to have Mr. Wilson's pre-filed direct testimony entered into the records as though given orally from the stand.
All right, Mr. Wilson's pre-file will be entered into the record as if given orally from the stand.
I would also move to have the exhibits attached to his pre-filed direct testimony identified as pre-marked Wilson Exhibits 1 and 2 entered into the records.
All right, his pre-filed exhibits 1 and 2 will be entered into the record as hearing exhibit number 8.
Mr. Wilson, did you prepare a summary of your testimony today?
Yes.
Could you please give your summary to the commission?
Thank you. Good afternoon, Madam Chairman and Commissioners. It is my pleasure to testify today in support of the settlement agreements as previously described by Mr. Davis in his summary. Prior to the settlement agreement, I filed direct testimony with the Commission in both dockets on April 28, 2015. My pre-filed testimony addresses Duke Energy Progress and Duke Energy Carolina's plans to issue requests for proposals, or RFPs, for utility-scale projects, for utility-scale solar energy production facilities. The companies initially proposed to issue an RFP for 10-year power purchase agreements, or PPAs, for projects between 1 megawatt and 10 megawatts in size. The companies also proposed to solicit bids for turnkey projects of the same scale. Unlike PPAs, which would provide the company with power only, turnkey projects would result in the companies taking ownership of a constructed plant. My testimony supported the company's plan to solicit both PPAs and turnkey proposals. However, I recommended that the Commission require that the companies solicit and consider offers of PPAs of longer durations than 10 years. My testimony recommended that PPAs of 20, 25, and 30 years should be considered, in addition to the 10-year PPA term, because longer-term PPAs typically result in lower financing costs for projects and lower prices paid for the kilowatt hours purchased. An analysis performed by the Southern Alliance for Clean Energy compared the prices for 10-year PPAs to 20-year PPAs based on information gleaned from solar developers. The analysis, which is included in my testimony, showed that longer PPAs yield a lower per kilowatt hour price for consumers. As part of the settlement agreements filed in these two dockets, the companies have agreed to extend the solicited PPA terms from 10 years to 15 years. We believe that the settlement should lead to successful implementation of Act 236 and the company's proposed distributed energy resource programs. Thank you very much.
Thank you. Madam Chair, members of the Commission, the witnesses are available for questions.
All right, thank you. Mr. Gall, any questions for these witnesses? No questions. Okay. Commissioner Randall.
Oh, yes, thank you, gentlemen, for being here today. Just one question, Mr. Davis. Do your clients have a preference, do you think, for the between rooftop or ground-mounted solar?
Well, I don't have clients. We have members
I didn't know
of the
exactly what the
Coastal Conservation League,
members.
and I interact with the
There you
community
go.
a good bit. We've heard a lot of interest in both. I think you heard from the previous witness and from Duke that depending on a person's situation, whether they're a renter, whether they've got a rooftop that makes sense, et cetera, you're going to have a different path that may be more attractive to you. So we expect both of those programs to be successful and attract investment from customers.
Thank you. Having heard that from different sides, I wanted to make sure your perspective there. Thank you.
Yes, sir.
All right, Commissioner Fleming.
Good afternoon. Nice to have you here. I wanted to ask, in your testimony, you talked about some carve-outs for the lower income customers. I wonder if you could tell us a little bit about that. And as I understand from the settlement, the collaborative will be discussing these over the next year.
Yeah, so the collaborative will be focused on answering that question in the next 6 months or so. I think that certainly the distinction that's been made between community solar, shared solar, and rooftop solar is one example of barrier to entry. So with shared solar, it's a lower upfront cost that allows you access to this resource, where if you're leasing your system, potentially there are credit issues associated. If you're purchasing your system, there's a large upfront investment that a customer has to be able to come up with. So I think what we want to ensure is that lower income customers also have access to these DER programs, and to the extent that there are opportunities for home bill financing or low interest loans, changing some of the subscription details with things like the shared solar program, that ensure access for those lower income individuals. We want to explore those options and apply them where they make good sense.
So that would be coming back before the Public Service Commission, once that?
It will be. I think the expectation is
Once you
that
reach
Duke would.
consensus, huh?
Right, consensus. Yeah, well, I think Duke will have, some flexibility to bring back those recommendations to the commission, but the expectation is they'll do that within the next year.
Okay. And the transparency you were talking about, could you elaborate a little bit more on that?
I believe my references to transparency and my testimony just have to do with ensuring that parties to this docket, as well as potential customers or participants in the DER docket, understand how decisions are being made with incentives and understand how these programs work, so that everyone's comfortable that these are cost effective and attractive to customers.
And do you think that that is there?
I think that's where we've ended up, and I think the settlement agreement puts us in a good position to continue to work through any changes and potential updates to the programs as we move forward.
And Mr. Wilson, I wanted to ask you, you had advocated for longer term leases or agreements. Would you, but the settlement calls for 15-year. Do you think you'll still get the cost benefit with a 15-year lease? I'm sure more than a 10-year, according to your testimony, but.
Yes, thank you, Commissioner. I do agree that a 15-year PPA term will be will result in a better cost than or a lower cost, excuse me, than the 10-year term.
Okay. Thank you.
Thank you.
All right, I just have one question for you, Mr. Wilson. You indicated in your testimony that you think that the value of DER generation should be recovered via the fuel costs and turnkey via base rates. Do you think that that is consistent with the Act?
I think that the Act language, as I read it, and I'm not an attorney, so I was primarily analyzing it from the point of view of what was presented in the testimony and in prior proceedings, and not as a legal expert. So I would defer to attorneys on the legality of what's being proposed. I think the settlement speaks to that, and I would refer sort of the legal interpretation to the attorneys.
Okay.
Thank
Right,
you.
that's fair. Thank you. And Mr. Davis, I'm sorry, I have to ask this.
Yes, ma'am.
I'm looking at your CV. I want to know what lured you back from being a surf instructor in Costa Rica to come back here. I mean, I just need to know that.
It's hard to pay off those law school loans on
Yeah.
surf instructor salary.
Well, no, I definitely feel you on that. All right, if there are no more questions, Mr. Holman, you have any more questions for your witnesses?
No redirect, I'll ask about surfing later.
Okay. Let me know what he tells you. All right, you are excused. Thank you, gentlemen.
Thank you, Commissioners.
All right, we will take a short 5-minute break before we begin with ORS and close it out. All right, Mr. Bateman, you ready, sir?
ORS calls this witness Lee Ford.
I do.
Ms. Ford, please state your full name and occupation.
My name is Lee Ford, and I'm the manager of the electric department for ORS.
And are you the same Lee Ford who pre-filed 10 pages of direct testimony in docket number 2015-53E on April 28th, 2015?
Yes, I am.
Do you have any changes to your direct testimony?
No, I do not.
If I asked you this questions today from your testimony, would your answers remain the same?
Yes, they would.
And are you the same Lee Ford who pre-filed 9 pages of settlement testimony in this case on May 14th, 2015, and 9 pages of revised settlement testimony on May 15th, 2015?
Yes, I am.
Do you have any changes to your revised settlement testimony?
No, I do not.
Why did you file your revised settlement testimony?
In my testimony for Duke Energy Progress, I inadvertently referenced numbers that were actually Duke Energy Carolina's numbers.
If I asked you the same questions today from your testimony, would your revised answers remain the same?
I believe I need to correct that. I referenced Duke Energy Carolina's numbers when they should have been Duke Energy Progress numbers.
Okay. And if I
I
asked,
apologize.
And if I asked you the same questions today from your testimony, would your revised answers remain the same?
Yes, they would.
Madam Chairman, we ask that Ms. Ford's pre-filed direct and revised settlement testimony for docket number 2015-53E be entered into the record as if it were read orally from the stand.
All right, Ms. Ford's direct and settlement testimony will be entered into the record as if given orally from the stand.
Thank you. Ms. Ford, did you prepare a summary of your direct and settlement testimony?
Yes, I did.
Please summarize your testimony for the commission.
Gladly. Good afternoon, Madam Chairman and members of the Commission. Before summarizing my testimony, I would like to clarify that when I reference Progress, I mean Duke Energy Progress, and when I state Duke, I mean Duke Energy Carolinas. The purpose of my testimony is to provide an overview of the Distributed Energy Resource Program Act, also known as Act 236, to describe the company's proposed Distributed Energy Resource Program application, and I'll shorten that by calling it a DERP, and to make recommendations regarding the company's proposed DERP. My testimony addressed DERP cost recovery and the company's plan to adhere to the caps in Act 236. ORS made recommendations of potential DERP modifications, including purchase power or PPA terms, solar rebate capacity limits and the assignability of solar rebates, shared solar and its compliance with Act 236, future low-income offerings, renewable energy certificates, future program modifications, and the formation of a DERP collaborative group. Subsequent to the filing of my direct testimony, ORS entered into a settlement agreement with all but one party in the docket, and as my counsel stated earlier, that party, the Sierra Club, supports the settlement agreement. The settlement agreement modifies the PPA terms from 10 years to 15 years. It also modifies solar rebate amounts, capacity limits, and as well as the rebate assignability and availability. It modifies the amortization of rebate cost, the company's avoided cost tariff, shared solar subscription cost and its compliance with Act 236, future ownership of renewable energy certificates, and future program modifications. ORS is extremely thankful and appreciative of the hard work and collaboration by all the parties in this docket, and we support the settlement agreement and find it to be in the spirit of Act 236 and in the public interest. ORS respectfully requests that the Commission approve the settlement agreement in its entirety. This concludes the summary of my testimonies.
Thank you, Ms. Ford. Now let's turn to docket number 2015-55E. Are you the same Lee Ford who pre-filed 10 pages of direct testimony in docket 2015-55E on April 28th, 2015?
Yes, sir, I am.
And do you have any changes to your direct testimony?
No, sir, I do not.
If I asked you the questions today from your testimony, would your answers remain the same?
Yes, they would.
And are you the same Lee Ford who pre-filed 9 pages of settlement testimony in this docket on May 14th, 2015?
Yes, sir.
Do you have any changes to your settlement testimony?
I do not.
If I asked you the questions today from your testimony, would your answers remain the same?
Yes, they would.
Madam Chairman, we ask that Ms. Ford's pre-filed direct and settlement testimony be entered into the record as if it read orally from the stand.
All right, Ms. Fort's pre-filed direct and settlement testimony will be entered in the record as if given orally from the stand.
Thank you. Ms. Ford, would you like to adopt your summary from docket number 2015-53E as your summary in docket number 2015-55E?
Yes, I would.
Thank you. Madam Chairman, ORS Witness Ford is available for questions from the Commission.
All right, thank you, Mr. Bateman. Mr. Gao, any questions for Ms. Fort? Okay, Commissioners, questions for Ms. Fort? Commissioner Fleming.
Good afternoon.
Good afternoon.
I wanted to ask you, well, let me just first, for clarification, can you tell me the beginning year for the 5-year period of the peak power use, the average? When does it start?
I believe in the application it is 2015, but let me look and see if I can find that offhand. And I may not have that.
So if it starts in 2015, then you won't know the actual numbers till 2020?
Let's see. I'm sorry, I should say that it concludes in 2015. Let me.
I couldn't find it anywhere, and it talked at different times.
All right. On page 5, I'm looking at the Duke Energy Carolinas application. That's the first one I grabbed. On page 5 in the footnote, it references that when they discuss their Tier 1, the utility scale, that 1% of the company's previous 5-year average, and they say 2012 to 2016. But then looking at the Tier 2, they also reference 2016 to 2020. When we looked at the numbers, because if you'll notice, the numbers that I reference in my testimony are slightly different than the total numbers that Duke referenced. We use that Tier 1 calculation, the 2012 to 2016 amount.
Okay, so it's officially, it's now being used for both tiers.
That is what ORS is recognizing, yes.
Okay, thank you. As I understand it, you're certifying the third-party vendors providing solar services?
ORS is also tasked with coming up with an application for third-party leasing companies. That is correct.
Okay. How will you determine that the third-party vendors are qualified to provide the solar services?
That is a very good question. We have been spending months and months developing an application. We've been speaking with those in this arena, the solar developers, conservation groups, the utilities. We've been seeking feedback from national organizations. Actually, South Carolina is, as far as we can tell, the only state that has an application requirement for third-party leasing companies. So we're learning a lot as we go along, and so there's a multitude of questions, and when that application is finalized, then it will be out for public consumption.
Okay, so you're setting the standards then?
Yes, ma'am.
For them, and they will have to meet those standards before they're accepted into the program?
Right. We are developing an application that will ask various questions, anything from, in the draft that I've seen, financial data, experience, years experience, any type of litigation, things along those lines. And we'll do it similar to what we've done in other industries to determine if they're fit, willing, and able.
Okay. And who will be responsible for the safety and maintenance of solar facilities not owned by the utility?
I think it'll depend on what type of agreement that person has. If it's a leasing situation, depending on the lease agreement, it may fall to the leasing company. If it's straight ownership, I would think the homeowner would have that responsibility.
Okay. But you're not certain of that at this point?
I would think, like I said, if it's a homeowner and they own it, it would be the same as if, my dishwasher went haywire and started sparking. It would be my responsibility to address the maintenance and safety of that.
Okay. But, so it would be whoever owns the facilities will be responsible?
Correct.
And, will the payback period be addressed in contracts that are set up between the entities?
In a leasing situation? I do not know the answer to that. I think it's up to the leasing company, but as a lot of things, and I think we're seeing this in the market, and I've gotten the impression from a lot of the questions that this is a concern of the commission as well, is I think to a certain extent some of this is buyer beware, and it's up to an individual to do their research. I know the question was asked about, will it impact your homeowner's insurance? What about your mortgage? And I kind of equate it to the fact that when my husband and I were looking to buy a house that had a pool, the first thing I did was call our insurance company and say, hey, what does this do to my insurance rates? What are my, what's the liability if we purchase this property? So I see it as a similar type situation where the consumer would have to do research on their own.
Well, it sounds like to me too, though, wouldn't there be kind of a Bill of Rights for consumer protection, so to speak?
And
that could address, set out, like where complaints go.
Absolutely. In ORS, we are aware of not necessarily a Bill of Rights, but group yes, no, I understand. Education for consumers. The Energy Office, which will actually become a part of ORS in July, along with the IOUs, has been working on consumer education. Anything from a checklist of, here are the things you need to investigate before you do this, whether it be contacting your insurance company, contacting your mortgage company, things along those lines. Leasing versus owning, who handles the operation and maintenance type thing. So that is out there. We're using best practices from other areas in the country. There are states that are much further ahead than South Carolina. So we're using lessons learned to help develop that. ORS fields calls from consumers now. I know the Energy Office fields a lot of calls, and we've even been in contact with the AG's office and Consumer Affairs as well.
So you're setting up that plus planning an educational outreach program?
There are, absolutely, and I believe Ms. Felt spoke to the Solarize and those types of things really aimed at consumers and that educational piece. So I think the education is happening in South Carolina. As this continues to grow, I think we'll see more of it, and we're excited to be a part of that.
And so as you're developing these processes right now, when do you think they'll be in place?
Some of it is going on as we speak. From the Energy Office perspective, I don't know because they're not a part of ORS at this point, but I do know they have been and continue to do consumer outreach currently, and I would expect that to be the case July forward as well.
So you feel like they will be the ones to handle the education and outreach?
I think that's a good portion of what they will do. ORS would handle the leasing side of it because Act 236 prescribes that. So I think we'd be involved in that piece as well as general consumer education. But I think they would continue the strong educational presence that they've had already.
So the consumer protection policies would be under ORS's, under your direct purview?
If it relates to leasing, and the application process would fall under ORS. Consumer protections, I would think would potentially be with Consumer Affairs or the Attorney Generals, but I don't know definitively on that.
Okay.
Now, if there's some type of conflict or anything like that, ORS would handle some of that as we currently do now with any type of consumer issue. But if you're starting to get into some of the other deeper issues, I don't know if ORS would be the right agency for that.
Okay, thank you.
Commissioner Whitfield.
Thank you, Madam Chairman. Good afternoon, Ms. Ford.
Good morning, or good afternoon.
I'm not sure if you're the right person or not. I see some of your ORS colleagues out here, maybe Ms. Schaefer or something. It's more of a cost and accounting question, but since you're the only ORS witness, I'm going to sling this one at you and see what you can do with it. Ms. Ford, with all our predictions and forecasts and so forth, we still don't always know exactly what participation levels might be and exactly how things are going to go with this or with anything else like fuel or anything else that is uncertain in the regulatory world. And I think you were in the room maybe when I was asking witness Ms. Kim Smith about the cost, and she used a number of say 10 million, and I think we talked about the 5.8 million and how we would have to continue, or the company rather would have to continue to collect until they recoup the other 4.2 million. And you know yourself from previous fuel proceedings that we've seen sometimes very large unrecovered balances be carried forward. What concern does ORS have as to what unrecovered balances might be carried and what the cost might be associated with that? Have y'all discussed that any? And again, I know that's not your area, but certainly you've maybe had some discussions with your colleagues, I hope.
It actually is a portion of my area, and we have discussed that. I think one of the greatest variables and unknowns in this is customer participation. You essentially can't require someone to do this. You can just make the best offering that you can to adhere to Act 236. We have looked at the potential for an under recovery. I think Ms. Smith addressed the fact that there isn't a direct sync between the cost caps and then the allocation of those costs, so there could be under recoveries going forward. Recognizing that, we recommended a 3-year treasury note plus 65 basis points as carrying cost.
Right.
Our economist pulled the number for me this morning. It is well under 2% at this point, even with the 65 basis points.
Right.
So as far as carrying cost, we felt comfortable that it would, allow the company to be made whole, but not overly burden the ratepayers with 12, 13% in interest rate.
Well, and I saw those numbers in your testimony,
Yes,
in the testimony, and I guess what I'm saying is, do you, of course, we don't know what the future holds, but do you see something like that getting kind of kicked down the road in the future? And of course, when that happens, everybody's paying, all classes, everybody's paying, and I just wondered if you had any discussions on that end at ORS.
We did, and because participation is the unknown factor, I couldn't say definitively how long this would go.
Ms. Ford, is that microphone on? The people in the back can't hear you. Okay.
It went out.
Is that better?
Yes.
Okay. Participation factors are unknown, and so we don't know when this potentially will end. I will tell you it would be beyond 2020. And I think Act 236 envisions that. It addresses the fact that these costs can be recovered well beyond the sunset of the DER program. And also I think it anticipates an under and over recovery possibility.
Okay, well, thank you. Thank you. You did answer my question
Well, good.
For the most part. Thank you. Thank you,
Thank
Madam
you.
Chairman.
All right, any other questions for Ms. Ford? All right, Mr. Bateman, any redirect? Okay. All right, Ms. Ford, you may step down. And Mr. Bateman, does that conclude your case?
It does.
Okay. All right, I'm going to have Mr. Butler read the exhibits for us so we are all on the same page. Please, sir.
Yes, Madam Chairman, I'd be glad to do that. I will read the list for progress, but I will tell you it's identical to the list for Duke Energy Carolinas up front. Exhibit number 1 will be the settlement agreement. Exhibit 2 will be Mr. Marino's direct exhibits 1 and 2. Exhibit 3 will be the late filed exhibit that was requested, having to do generally with avoided cost tariff effect on existing customers. Exhibit 4 will be the Smith direct exhibits 1 through 5. Exhibit 5 will be the application in this case. Exhibit 6 will be Mr. Barnes' direct exhibit JRB 1. Exhibit 7 will be Mr. Davis's pre-filed direct exhibit number 1. And exhibit number 8 will be Mr. Wilson's pre-filed direct exhibits 1 and 2. And that does complete the list of exhibits, Madam Chairman. And again, as stated, the Duke Energy Carolinas list is identical.
All right, excellent. Thank you, sir. Proposed orders by June 24th, 2015. Is that fine with everyone? Okay, excellent. All right, well, thank you to all of our parties for a fairly painless hearing. Thank you also to our cameraman. We appreciate you. We'll see you in a few more weeks, and we are adjourned.
Yeah.